Ayubowan, Vanakkam, and welcome. You are tuned on to the Bar Association webinar series, and it gives me great pleasure to remind you that it is the 20th episode of this series. When this series started, it was at a time where Sri Lanka was in lockdown, and today we reach the 20th episode. If you tune on to the first episode, which is available on our YouTube and social media platforms, you will hear the president of the Bar Association calling it a novel initiative. Later on, we have the secretary of the Bar Association, Mr. Rajiv Amarsurya, attorney at law, also talking about the importance of the profession coming forward as practitioners that embrace technology. When the series started, it was directed at law students and raw recruits of the profession. Now we are pleased to have the participation of not only lawyers in Sri Lanka, no matter in the regions, provinces, Jaffna, Colombo, Kandy, Galle, wherever, through the net, but also members of the Bar Association that are not in Sri Lanka. So it gives us great pleasure, and we are so encouraged by the participation of learned counsel, by the participation of senior attorneys, and the 20 moderators who have done an excellent job moderating these sessions for us. So welcome to the 20th episode. This is your panel of experts, and the topic of discussion would be impeaching the credibility of a witness in a criminal trial. We have with us the following experts: Mr. Priyantha Navana, President's Counsel. Having called to the bar in November 1989, he practiced law both in trial, appellate courts covering criminal and civil until he took up the appointment in the Attorney General's Department as a state counsel. After completing sessions of criminal prosecutions before the High Court of the Republic of Sri Lanka over a period of 3 years, he conducted miscellaneous criminal prosecutions on a wide spectrum of subjects. He holds an LLM, an LLB from the University of London, United Kingdom, Diploma in Forensic Medicine and Science, University of Colombo, Diploma of Oceans Law and Policy, Rhodes Academy of Oceans Law, Greece. He has also served as a visiting lecturer at the Open University of Sri Lanka and also as a lecturer and an examiner at the Sri Lanka Law College. We also have with us Mr. Sanjay Gamage, attorney at law. He is a solicitor. He is a senior practitioner. He is a council member of the Sri Lanka Institute of Advanced Technology. He is a member of the Legal Aid Commission Sri Lanka. He was the deputy chairman of the Public Utilities Commission of Sri Lanka and also holds the post of the former secretary of the Bar Association of Sri Lanka and has acted as a former president of the Colombo Chief Magistrates Court Lawyers Association. We have with us Mr. Asela Rakava, attorney at law. Mr. Rakava practices in criminal law, commercial and civil litigation, as well as fundamental rights application. He practices in primary courts as well as appellate courts. He has served as a chairman of the disciplinary committee in Sri Lanka Cricket and now serves as a member of its constitutional committee. We are also pleased to have with us Mr. Asela Serasinghe, attorney at law, who holds an LLB from the Open University of Sri Lanka and joined the Attorney General's Department in 2007 and served as a prosecutor and a state counsel. Our moderator for this session will be Nayantha Vijayasundara, attorney at law, who holds an LLM and an LLB from London and has a PhD in conflict and peace studies. Nayantha, over to you.
Thank you, Tanya. Cross-examination is actually a very important aspect of any given criminal trial. It's an art form to be perfected by any trial attorney, any trial lawyer who is worth their salt. Principally, in a cross-examination, we expect to achieve one of the two objectives. Two main objectives of a cross-examination would be to elicit from a witness an alternative narrative which did not come out in the examination in chief. The other main objective of a cross-examination would be to impeach the credit of the said witness. So without further ado, may I call upon Mr. Nawana, President's Counsel, to make a few introductory remarks on the issue of the credibility of a witness and how important it is to impeach the credit of a witness that is presented by the opposing party, and the relevant legal provisions in the evidence ordinance in this regard. And sir, if I may further trouble you, to share your knowledge and experience on making or treating one's own witness as an adverse witness when that witness threatens to jeopardize the integrity of one's case. Mr. Nawana, sir, the floor is yours. Mr. Nawana, sir, perhaps you could unmute the microphone. It still says, perfect, sir. Thank you.
Okay, sorry about that, Labs. I must thank the BASL for inviting me to take part in this session. And the topic that has been chosen this time is of material importance in the conduct of affairs in a criminal trial. Now, before I get into the substance of the topic, let me give you an overview of what I am planning to do. First, I'll speak to you on why credibility of a witness is important in a criminal trial. Then I would be dealing with how the credibility is impeached. Finally, as was requested by Nayantha, I would be dealing with how a witness could be treated adverse and when that shall happen. Now, before getting into substance, I think it is important to get into the fundamentals of criminal law. Now, success of a criminal law depends on the proof of the constituent elements of an offense. Now, the success or the proof of the elements of the offense depends on the credibility of the witness or the witnesses. Therefore, the credibility of a witness plays a significant role. And this is so important, especially in the context of the jurisprudence relating to criminal law. We all know that there is an inviolable principle that always operates in favor of an accused person. That is the presumption of innocence. With this principle, the inherent other matters which come to light are the burden of proof lying on the shoulders of the prosecution. And also the prosecution has to be mindful of the very high degree or the standard of proof being the proof beyond reasonable doubt. Also, if there is a doubt, the doubt has to be resolved always in favor of an accused person. So the law is heavily weighted against the prosecution. There is a heavy burden on the prosecution when establishing a case. So the evidence is the vehicle to reach the destination of the proof of offenses. In that, the credibility plays an important role. The prosecution has always to be mindful of structuring its case in a manner that its evidence is credible and beyond any blemishes. Therefore, when presenting evidence, it has to bear in mind that the credibility of a witness or witnesses should not or could not be assailed if it is really interested in securing a successful prosecution. Now, therefore, the prosecution in navigating the case should always navigate the case through the channels of consistency, probability, and impartiality. There are other tests. I'm not dealing with those for the time being in view of the time constraints. The prosecution has to at least be mindful of those areas when structuring and presenting a case. Now, in as much as the prosecution is taking every effort to present a case with credible evidence or with the evidence which it believes to be credible, the defense always tries to demolish the prosecution case. The impeaching of credibility is an important weapon. I would say it's a very, very heavy weapon, which is found in the armory of the defense to destroy the prosecution case. Therefore, the prosecution has to guard itself against this heavy weapon of impeaching, the possibility of impeaching the credibility of a witness. Now, in this regard, I would think that it is pertinent to refer to certain provisions of law which has a direct bearing in relation to the credibility of witness in assessing and determining a case which is undergoing a trial. If the evidence is not found to be credible, then there are certain provisions both in relation to a trial before the magistrate and also in relation to a trial before the High Court, where the proceedings could be terminated abruptly. You all know, in terms of Section 186, if the evidence is not reliable or credible, the magistrate is empowered to enter discharge or an acquittal, as the case may be, and the proceedings could be terminated from that point onwards. Similarly, if the evidence is discredited before the High Court, before the closure of the prosecution case, the case can be discontinued with an order of acquittal. So those decisions are purely made on the basis of the lack of credibility of the witnesses. So these are the fundamental reasons as to why one has to be very serious about leading or placing the credible evidence before court in a criminal trial. Now, the impeaching the credibility of a witness could be found in the provisions which are being dealt with under the evidence ordinance in terms of chapter 12 of the evidence ordinance. Now let me refer to important provisions of law as found in the evidence ordinance. Firstly, Section 145 of the evidence ordinance deals with the first principle with regard to the cross-examination. Now, this provision deals with a situation as to how a person or a witness could be contradicted in relation to a former or previous statement. The section also deals with how a witness could be contradicted in relation to an oral statement that he has made previously before the trial is taken up. Now, the evidence audience further makes provision in terms of section 146 elaborately with regard to the credibility, veracity, accuracy of a witness. Now, in asking questions in examination, the defense counsel always could make use of these provisions to attack the credibility of a witness as he tries to find out the veracity or the accuracy of the evidence that he has presented to court. Section 146C also deals with the ability to shake the credit of a witness by shaking or by injuring the character of the witness. Now, therefore, you would see that these provisions are really powerful provisions which enable a counsel for the other side or the defense to attack the credibility of a witness. Now, section 155 also makes provisions in a wide spectrum where the credibility or the impeachment of the credibility is made possible. If you look at section 155A, that makes provisions enabling an opposite party counsel to place evidence from another witness to assail the credibility of a witness in court. 146B makes provisions as to how the credibility of a witness could be attacked on the basis of an allegation of taking a bribe to testify in favor of a particular party or the prosecution. Or there could be also situation as provided under the section to establish that the witness has been induced by some other extraneous reason to come forward and give evidence against the accused. Similarly, the other important area of impeaching the credibility of a witness, as I referred to you before, on the basis of section 145 and 146, that the defense counsel could attack the credibility of the witness on the basis that he has made an inconsistent statement or he has taken up an inconsistent version at a previous stage. Thereby, an inconsistency could be brought into the fore so as to affect the credibility of the witness or to assail the entire gamut of the prosecution. Now, there is a specific provision with regard to a specific charge of rape where the defense counsel can attack the character of the victim prosecutrix on the basis that she possesses an immoral character. That is, on the basis that the consent or the presence of consent is a material element to establish a charge of rape. Now, if I am permitted to advert to the day-to-day happenings in a criminal trial, we all know how often that we mark contradictions and omissions in the course of a trial. As a prosecutor, we really are afraid of that exercise because that has the inefficacy, as I said before, of damage in our case. The defense counsel use V1, 2, 3 or whatever and mark a series of contradictions in relation to previous statements, basically police statements. Whenever the witness is brought to a situation where he has given different evidence as opposed to the previous statement at the trial. So all these contradictions and omissions are marked on the basis of section 145, 146, which enables the procedure, and 155 of the ordinance. So these are the provisions in our statutory regime which enables the opposite party to mark contradictions or advert to the areas of omission, because when you are referring to an omission, you can't mark because it is non-existent. So therefore you can't give a marking, but you can advert the attention of court to the omission on the basis that this particular fact had not been referred to by the witness on the previous occasion. Now, finally, treating a witness adverse. These are, Nayantha, I hope that I have a little more time.
Of course, yes, we can take a few more minutes there. And yes, of course.
Yes. Treating a witness adverse is a very, very important but a critical event. When an application is made to treat a witness adverse, it is a very difficult and important call that the prosecution is making. Now, if you look at section 154, which enables the procedure, what the section says is that it allows you to ask questions in a way that the opposite party could have asked from the witness. That does not refer to adverse witness or an hostile witness, even though in our common parlance, we always refer to them as hostile or adverse witnesses. Now, the application to make a witness adverse should be made in exceptional situation where witness has given evidence which adversely affects the prosecution case and it counters the dimensions of the prosecution case. And the application should never be made on the premise that the witness has given some unfavorable evidence on a particular fact, or the prosecution is, or the witness is not advancing the prosecution case to the extent that has been expected of him by the prosecuting counsel. We need to bring into bear that the judgment is made objectively. Now, an important opportunity of treating a witness adverse is a situation where he has made a diametrically opposite statement as opposed to what he is testifying on now in court. And that former statement should refer to the vital ingredients of the offense, or his statement has remarkably subscribed to the founding of the prosecution case. Simply because he has deviated from a particular position, the application should not be made by a prosecuting counsel to treat him adverse, because that could bring in adverse results and the consequences too. Now, once the witness is treated adverse, there are certain consequences that would follow. The court would be put into a situation of dilemma. What to do with this evidence, whether to accept and act on, or whether to reject. Now we have judgments, a wealth of judgments, I would say, in favor of both theoretical positions. One set of judgments says that it should be totally rejected, and the other says, no, there is no requirement as such, that evidence could be considered and taken to be considered in determining the guilt of the accused. The judgments also now have come to a compromising position, suggestive of the fact that the position is really dependent on the facts and circumstances of the case. Now, in this regard, I would also refer to the maxim, that is, falsus in uno, falsus in omnibus. That is, if a witness lies on one point, is said to be lying on all points. Now, the principles and the maxims have been referred to in King versus Julius, which is a very important judgment which has dealt with the principle. And this maxim was also dealt with in the case of AG versus Samaravira in 1990. I think it is 2 SLR 256, where exceptions were admitted on the basis that a witness could deviate from his original position due to the lack of observation or faulty observations or loss of memory and so on and so forth, or embroidery, that is to exaggerate his position quite innocuously. So those are the matters that one should consider in dealing with a witness being treated adverse. He should make an objective decision so as to ensure that prosecution case is not gravely affected as a result of this call of making the witness adverse. So those are the fundamental remarks that I would propose to make in terms of the segment that had been allotted to me.
Thank you very much, Mr. Navana, sir, for sharing that wealth of knowledge and actually cramming all that knowledge into such a short time slot given to you. Building on what Mr. Navana had shared with us, may I invite senior practitioner Mr. Sanjay Gamage to take us through how inconsistencies, then improbabilities, and also delay on the part of a witness could affect the credit of that witness, and how the defense could perhaps manipulate such weaknesses to their advantage. Mr. Sanjay Gamage, sir, you could begin your segment now, sir.
Yeah. Thank you, Nanta. Good evening, everyone. I will briefly discuss the aspect of inconsistency and improbability and delay could affect the credibility of witnesses who testify before the courts. Hello?
We can hear you clearly, Mr. Gamage. The video, if you could switch it on as well, it would be perfect. Okay.
Now, first of all, I will explain. Mr. Navana very clearly explained covered all the impeaching.
If I may interrupt for just a second, I think your video has dropped. I think something may have inadvertently been pressed, I suppose. Perfect. Carry on, sir.
Yeah. First of all, I will explain what is the mean of the credibility of the witnesses. The evidence given by the witness can be acted upon by courts only if the courts conclude that the witness has given a truthful testimony. Therefore, the court should be satisfied with the credibility of witnesses in order to conclude that the witness has given truthful testimony. So if there is a doubt regarding the credibility attached to a witness, the court will reject some witness's testimony as considering it not to be not creditable. For that purpose, we have need to get the cross-examination. What is the cross-examination? Cross-examination can be considered as a mechanism that we use to evaluate whether the evidence given by witnesses is inaccurate, true, and whether the evidence should be accepted by the courts.
Mr. Gamage, sir, I hope everything's all right.
I see technical errors, signals are very difficult. Can you hear me, Nayanta?
Yes, sir. Can hear you very clearly. I understand, sir, you're participating from outside of Colombo, and you are from yes. So even without the video image, if it's interfering with the signals, we can continue, sir. And we can hear you very clearly.
Yeah, very difficult. I don't think the technical error in that video was come that on the button also, but there's no. Okay, now
that's all right. Yeah.
We speak about the cross-examination. That is very important things in the criminal matter. And if the witness is able to withstand the cross-examination and if his evidence remaining undamaged, the court could act upon such evidence. But if the evidence given by witnesses is damaged with doubt on the basis that such evidence is not credible, then the court can give sufficient reason and reject such evidence. Therefore, in my opinion, cross-examination is the utmost important and considered as a key of approach impeaching of the credible witness. So my topic is now moving into topics of the impact of the inconsistency of evidence on the credibility of witness. Inconsistency affects the credibility like this. If the courts observe that the witness has been inconsistent with material facts that goes to the root of the case, his evidence could be rejected on the basis on credibility. Such inconsistency under section 155C of the evidence ordinance very clearly stated, it can be established in two methods. One is marking a contradiction, other is the providing proof of former statement. Those two methods can be defined as contradiction and omission. The contradiction occurs is an instance where the witness having spoken of the incident in different ways at different times. If the witness take up a different position while giving evidence in court, an inconsistency will be disclosed. In such a situation, the counsel should raise the inconsistency and mark it as a contradiction. And also, if the witness omits to speak of a material facts in either police statement or at the non-summary and he speak of such fact at the trial, it would constitute an omission. Therefore, If such a inconsistency does arise, it may be considered a factor deciding the credibility of witnesses' evidence. In the case of Chitti versus Piris 41 NLR
I think we are having a slight technical difficulty there. Mr. Gamage has been gracious enough to accept our invitation and join from all the way from Anuradhapura. I think there is some interruption and some issue with the internet connection. In the meantime, until Mr. Gamage comes on, perhaps we could take a question or two, because I see some interest from our membership and some questions have already been posted our way. If I may ask you, sir, Mr. Navana, one of the questions is, sir, it's a fairly simple question. Can we apply section 146 of the evidence ordinance to both criminal and civil matters?
Yes, of course, yes. The section 146 does not make a distinction between the civil and criminal cases. The contents of section 146 are of general application. Therefore, those provisions can be resorted to both by practitioners in civil cases as well as in criminal cases. That is the empowering section. That is the empowering section, which is of general application.
Thank you very much, sir, for that quick and succinct answer. Mr. Gamage, sir, are we in a position to proceed? Is everything all right in terms of the internet connection?
Can you hear me?
Yes, sir. Please continue. We went for a quick question until the technical issues were sorted out.
But my switch not only that video, so I'll try.
That's all right, sir. We can hear you very clearly. Please continue, sir.
Now we move into second point of the impact of delay, lack of prominence of the evidence, credibility of the witness. How it credibility of the witness, lack of prominence affects the credibility of like this. The lack of prominence can be also defined as a delay in taking action, in attacking the credibility of witness. The position that can be taken into highlight the delay on part of the witness or complainant in making their statement to the police. The general position taken is that the complainant must be prompt and making a complaint. So,
Mr. Gamage, we can intermittently see you, and the video comes on and it goes off. How is the microphone working? If you could unmute, sir. Perfect.
Nayanta, there is a technical errors coming in with this. Anyhow, Nayanta, could you please to proceed with the others, then I will check this by device and I will join with you.
Very well, sir. Very well. Very well.
I
And
will join.
very well, sir.
Okay.
Thank you very much, sir, for the trouble taken from joining us from afar. May I, in that case, move on to Mr. Asela Serasinghe, an experienced practitioner, both as a prosecutor and a defense counsel. Asela, Mr. Gamage, in his segment, mentioned that the marking of contradictions and raising of omissions are two methods that could be used to impeach the credit of a witness. Asela, as an experienced trial lawyer, would you like to share with the membership the process by which we mark contradictions, that is from the statements made previously and also from evidence given by that same witness, and also the process of raising omissions, how these processes happen and how they should be done, and also the impact of them. Sometimes, Asela, you might be knowing there are certain contradictions that should better be left alone without trying to mark them and jeopardizing your case. So I'm sure you could elucidate, you could enlighten our membership on these aspects. So if you could take over, Asela.
Yes, thank you, Nayanta. I will go straight into my issue, is how you mark a contradiction. Now, the first matter to keep in mind, dear listeners, you have to be very conversant with section 145 of the Evidence Ordinance. Now, section 145 of the Evidence Ordinance will explain as to how previous statements can be used to contradict, to demonstrate that a witness has said one thing in his previous statement and now in his evidence he takes a different stand on the same matter. Right. So now let me take a small illustration or example just to make it very simple and practical. Let's think that there is a case of murder, and there is a purported eyewitness who says that he saw the attack. And in the police statement, this eyewitness has said in his police statement soon after the incident, he says that the accused came to the scene in a motorbike. And I saw the accused attacking the deceased, and I saw him leaving in a motorbike. Now that is his statement given to the police. Now the first thing when you go to defend a case of this nature is that you have to be thorough with what the previous statement says. Now the previous statement could be a police statement that is recorded under section 110 of the Code of Criminal Procedure Act, or it could be evidence in a non-summary inquiry, or in a murder case, it could be evidence given at an inquest. So now this witness says that the assailant came in a motorbike and left in a motorbike. Now, when this witness, purported eyewitness, is giving evidence in court, this witness, we will assume, now he says that the accused came in a three-wheeler, he attacked the deceased, and he went away in a three-wheeler. Now, as the defense counsel, being thorough with your previous statement, you will know, yes, now there is a very serious contradiction. Why? To the police, he said that he came and went in a motorbike. In the evidence, he says that he came and left in a three-wheeler. Now, it's a significant matter because if he was there, he could not have made such a serious error. Now, how do you put this contradiction? You know there is a contradiction, and you know that this contradiction is quite material, because a difference between coming in a motorbike, coming and going in a motorbike, and coming and going in a three-wheeler is a serious discrepancy. Now, the first thing you must do is you must box in the witness to his position in the witness box. So you elicit from the witness that he says with categoric certainty that I saw this, that he saw the assailant coming in a three-wheeler, nothing else, and leaving in a three-wheeler and nothing else. So now you have taken the contradictory portion and boxed him in the witness box. Next, it is only then that you put the previous statement to the witness. How do you say it? You can ask the witness, did you give a statement to the police station on such and such a date? Then you can ask him, in the statement, with regard to the same issue, did you state as follows? And you repeat, you quote the same statement where he says, came in a motorbike, left in a motorbike, verbatim you put it to the witness. And now the witness can say many things to that. He can say, yes, I said it. Now, if the witness says, yes, I said he came in a motorbike, he went in a motorbike, now then you can't mark a contradiction there. Because he has accepted that he has said the motorbike story in his police statement, and also he has, in his evidence, he has told the three-wheeler story. Now, your task as a defense counsel is to put the suggestions to the witness that both versions cannot be correct. If you accept the statement you made to the police as true, then you have uttered falsehood in court, under oath. If you only accept the version you said in the courthouse, then you have uttered a falsehood in your police station. So that is one scenario. Now, what if the witness says, I never said that in my statement? He denies the statement. Then, Nayanta, that is when you go into the marking of a contradiction. Then you can put to the witness, I put to you that in your police statement made on such and such a date, you stated as follows, and then you repeat that portion, which is contradictory to his evidence in the witness box. Then even if he denies, or if he denies making that statement, still you can, with the permission of court, you can mark that portion of the statement as V1 or V2 and draw it to the attention of court as a contradiction. Right. Now the most confusing thing happens, Nayanta, and Asera Rako also will know, the most confusing thing happens when the witness gives an evasive answer. He says, I don't know, I can't remember. Now I can't remember, a lot of time has passed, I don't know. Now that is where sometimes we run into difficulties where sometimes there are instances where even judges don't permit counsel to mark a contradiction. And sometimes the prosecutors also might object. Here, I think there was a question also posed by one of our participants. What do you do in that scenario? Now, I will quote a portion from Saka on evidence. And Saka says as follows. In order to admit the previous inconsistent statement, it is sufficient if it is not distinct, admit the previous inconsistent statement, it is sufficient if it is not distinctly admitted, or if the witness pleads failure of memory or gives an evasive answer. Otherwise, the witness might save himself from self-condemnation by pretending that he does not remember having made the statement. So now it is very clear, if you read section 145 and also Saka on evidence, even if the witness says, I can't remember, or gives an evasive answer, still as a defense counsel, you can suggest to the witness, in your statement you have said this, and now you state this. On that basis, you can, with the permission of court, you can mark that contradiction. Now, the next thing, Anant, is that you must prove the contradiction, because there are judgments to say that if you don't prove it, or if you don't bring it to the attention of court in the proper way, then it might not be considered. How do you prove the contradiction? First thing is, if you can get the prosecution to admit the contradiction under section 420 of the Code of Criminal Procedure Act, then that is sorted. If not, if the prosecution is not willing to admit, then if the prosecution is calling the police officer who recorded that statement, you can cross-examine that police officer and say, put to him that you recorded this statement in the correct way, read it over, witness signed it, admitted that it is correct, and in that statement is the following portion there. Then you can quote V1 or V2 and say that that portion is there. Then you have proved the contradiction. Then what about the omission? Omission is a situation where the witness is coming out with a new part of evidence for the first time. We'll take a case of murder. In the witness in his police statement says that the accused attacked the deceased. That is in his police statement. Now when he comes to the witness box, he adds something more to it. He comes and says, I saw the accused attacking the deceased with a sword. Now that sword story was never there in the initial police statement. So now you know that he has come up with something new for the first time. Then you put to the witness in your cross-examination that you, soon after this incident, you made a statement to the police and you had ample opportunity of explaining what the incident was. And it was closer to the time of the incident. But you have not uttered a word about a sword being used at all in your police statement. And then you draw it to the attention of court. You draw it to the attention of court that on such and such a statement made by the witness, he has never mentioned anything about a sword. And that also, as an omission, we don't normally give it a marking. It's a mention or you draw it to the attention of court. Omissions also you can, if you can get it admitted, if the prosecution can admit it, then you don't need to prove it. But if not, you will have to call the witness who recorded the statement and elicit from him that the omitted portion was not contained in the initial state. Right. Now, that is the most important aspect of marking omissions marking contradictions, drawing to the attention of court omissions and proving them. Now, Nayanth, you also mentioned that just because there is something contradictory between the police statement and his evidence, it is always not to your benefit. It won't always be to your benefit to mark it. For example, there may be very minute and insignificant contradictions, which marking it might actually demonstrate that you might not have a proper way out with this witness. And that is because of that reason you are marking insignificant, unimportant contradiction. The other thing is sometimes the evidence, there may be certain portions of evidence which are contradictory, but by marking it, but by trying to mark that portion, what if the witness says, yes, I said it? If he admits that portion and says, I am sorry, I forgot to say it earlier, but this also happened, then you have actually, by trying to mark something, you have added on to the evidence of the witness. So I think the most useful thing to do is look at the case in its totality and see what your defense is. And then in that defense, if you are trying to discredit the witness, try to use the most potent and important contradictions and omissions. And also, Nayanth, if I have some time, I hope I'm not going overboard. I think there was also a question.
Yes, you can actually take some time, Marcel. That's not a problem.
Right. So there was another question also posed by one of our participants as to the notes made by police officers. Now we know in terms of section 159 of the evidence ordinance, police officers and certain government officials are entitled to make notes on the official duties that they are doing, and they are also entitled to peruse those notes to refresh their memory when they come to give evidence. Now, in narcotics cases, most of the narcotics cases and cases where police witnesses are the predominant witnesses, you find that they will come to the witness box with their notes and they will use their notes and give evidence. So that is permitted. Now, how do you elicit contradictions and omissions in that scenario? I think it is useful to read section 159 and 161 of the evidence ordinance, because if a police officer is using such a note from his information book notes to refresh his memory, then the defense is entitled to peruse it. They are entitled to peruse it, examine it, and cross-examine on the contents of that document. So in that scenario, now I recall a matter when I was prosecuting in a narcotics case, where the witness in his note, in one part of his note, he has said that the narcotics was recovered from the left trouser pocket. But in another portion of his note, he has said that the narcotics was recovered from the right trouser pocket. And we had a learned trial judge who would not take these discrepancies lightly. And once that matter was brought to the attention of court, in his note, one portion says left pocket, another portion says right pocket. On that basis only, that accused was acquitted. In that scenario, it might not be necessary to mark that portion of the note, because you can put it to the witness. In your note, does it state as follows in this particular portion? And also then you can cross-examine with regard to the other portion of the note and says, in the other part of your note, does it say as follows? So it will be self-explanatory that he had made two contradictory statements regarding the same issue. Omissions also, the fact that he had not recorded something vital in his note can be drawn to the attention of court. Now, also going a bit further from there to my last part is contradictions, omissions, discrepancies, and there can be also contradictions within the evidence of one witness. For example, in the evidence in chief, he says, but he takes a particular stand. In cross-examination, his stance will change. Now, in that circumstances, also you don't need to mark that contradiction as such, but you can put to the witness, or you can in your submissions explain that under oath he had on such and such a date taken this stance, and on the next portion in cross-examination he had totally taken different stance. Now, putting all these contradictions and omissions together and trying to discredit this witness is finally a matter that you have to face at the submission stage, because you will have to remember, as Mr. Priyantha Navan, President's Counsel, very clearly said, you will be confronted with the very potent judgments of Samaravira versus Attorney General, 1991 SLR 256, and the often quoted Bogibai Hirjibai versus State of Gujarat, where these infirmities of evidence, these contradictions, omissions the prosecution will try to reconcile in the light of those judgments. So simply without trying to demonstrate there is something different between one portion of his statement and another, it would be useful to try to explain to court the gravity of these contradictions and omissions. If you can impress upon court, if the eyewitness was present at this time, in this environment, he could not have made this erroneous or wrongful stance, and he could not have taken such a different stance on two different occasions. Omissions also, if it was such an important matter, and the witness was able to come out with these important matters at the outset, then why is it that it was never brought to the light of court? Actually, it comes into the realm of spontaneity and delay that Mr. Sanjay Gamage was talking about, delay. Why didn't he say this? So we must try to tie it up with other possibilities. For example, maybe the witness changed his position because later on, maybe the investigation recovered other evidence. Maybe other witnesses had come out with certain other information and evidence. We'll have to try to explain to court that maybe perhaps due to that reason, the witness has changed his stance so that he can fall in line with some of the versions of some other witnesses. So I think, Nayanta, I will at this point conclude with that and leave the floor to you.
Thank you very much, Asela, for that very detailed and clear analysis and explanation on how to mark contradictions, how to raise omissions, and how and when to pick them, because we all know that this is actually a bit of a sore point where trials or a defense case, or even the prosecution's case, if a good defense witness comes, is either made or broken. Developing on that and moving on to a more specialized area, may I invite Mr. Asela Rakava to share some thoughts on impeaching the credibility of official witnesses and also experts. Official witnesses, Mr. Asela Serasinghe touched on
Yes.
some aspects of it when you discuss, especially in narcotics cases and the notes made by police officers. But of course, Mr. Rakava, you are free to elaborate on that, and also more importantly, perhaps enlighten the membership on our viewership on how to cross-examine and impeach the expert witnesses such as a government analyst, EQD, and also the judicial medical officers that are brought by the prosecution. Over to you, Asela.
Thank you, Nayanta. I have to thank the President's Council, Navan and Asela. They elaborated on the aspects of the evidence ordinance and spoke of section 145, 155, and 154, where Mr. Navan brought the real truth of a criminal trial. It is, Mr. Navan said that the fundamental principle of a criminal trial is the determination of the truth. So while determination of the truth, it is the duty of a judge to find out the truth placed by him through evidence. So the evidence in a case plays a very, very vital role. So during this webinar, we were trying to establish that it is very important to determine the truth and the veracity of evidence given by a witness in a court of law. The duty of the prosecutor would be to bring about the position of the prosecution case. As Mr. Navan correctly suggested, we are at the defense counsel will have the duty to destroy the prosecution witness in total. So that will be our duty towards the accused. In doing this, I think the Asela spoke about some of the official witnesses and brought about some technicalities where how an official witness will come and give evidence and how we can cross-examine and contradict an official witness. So these police officers and the police officers who are working who are attached to the bribery commission, on a daily basis, we see them coming and giving evidence in a court. of law, especially these bribery commission of officials. The investigators I have seen comes and gives an evidence, and they are also supported by a decoy who had been standing right next to the complainant. So when we are trying to impeach the credibility of those witnesses, it is important that we discredit the evidence given by these people. So for this, fortunately, in bribery matters, we are privy to all these statements. But sometimes there are these PNB notes, IB extracts, and investigation notes, which normally the police officers are a little bit reluctant to give us. Then how are we going to get access to these documents? Fortunately, after the case of Vijaypala versus AG, we were given a little bit of a free hand to ask for these documents, where it was decided for a fair and a free trial, these documents should be, if these are accessible to the prosecution, we should also be given copies. So nowadays, we use this judgment, and in a court of law, we tend to ask for these documents through this judgment. So by that, I think we make this, we try to impeach the credit of these witnesses. Like Asela said, the fundamental and the difficult situation we face in a court of law is when the witness is uncertain. When witness had said something in evidence in chief, when we try to cross-examine, the witness comes out with different answers. I can't remember. Some say that I can remember, I said something like that. So they go on a voyage where they try to confuse us. I think it's a problem, and I think it's a lapse on our part. Sometimes the defense counsel do not get what they want to get it made concrete. If we like for a simple question, we ask a question and the witness comes out with a statement, "Oh, Mahatya, mama giye 3-wheeler," like Asela said. Then without we getting it established, we straight away try to ask a question which is in the police statement and try to contradict the witness. I think before we do try to contradict the witness, we should make sure that the witness is told that in your evidence in chief, you said that you saw this particular person went in a 3-wheeler. Are you certain about it? Are you 100% certain about it? Are you telling the truth? This is my famous thing in court. I always ask, අබමල් රේණුවක් තරම්වත් අවිශ්වාසයක් නෑ නේද මහත්තයාට මේක. මේකට යමක් විරුද්ධව යමක් කියනවා නම් ඒක මහත්තයා කියන්නේ බොරුවක් නේද මහත්තයා. So I try to get it concrete that the witness had said the particular thing in evidence in chief, and from the witness's mouth I try to get it that nothing other than this is true. After that only we should put it to the witness. You went and made a statement in the police station. You said the right, whatever right things. Then if you said that was right, what is this? I think by doing that, we will always be able to corner the witness. After getting that, it will be easy for us to get this contradiction. But on a day-to-day basis, I have seen in court, lot of defense counsel lose this. The witnesses try to take us for a ride. I think we should never let that happen. We should always be mindful that we should establish and we should know the answer of the witness. Like Mr. Dayapera used to tell me always, never open your mouth and ask a question from a witness in cross-examination if you do not know the answer. You should know the answer what the witness is giving you. If you know the answer only, you ask it, then only you can mark the content. Don't go on a voyage of discovery. I think that is not our duty. Our duty is to have contradictions and mark the evidence. That I think I stepped upon Asela's area. Now, I think apart from the normal witnesses, the lay witnesses we see, there is under section 45, it is said that when the court wants to form an opinion on some special aspect, the court permits people with special skills to be called to give evidence and formulate an opinion in court. So it is the duty of the prosecutor in situations like this. Initially, the prosecutor will have to inform court that in this situation, they need an expert. And secondly, the prosecutor will have to establish this person whom we are bringing to give evidence is an expert. After that, only an expert will be taken to give evidence. Commonly, there are doctors who come and give evidence. There are examiners of question documents who come and give evidence. There are officers of the government analyst department who come and give evidence. These are people who come and give evidence, and those people express an expert opinion. They have no interest with regard to the outcome of the case. They are only before court to express an opinion, and they themselves say that they are experts of this trade. And I think this is an avenue where, as a defense counsel, we have to be very, very careful. On a day-to-day basis, when we try to, in so many cases, when an expert witness is called by the prosecution, the tendency of a judge, of a trial judge is, always the trial judge will ask us as the defense counsel, why not you, Mr. Rakava, why not you admit under 420, you can admit his expertise, you can admit. So that's sometimes it becomes ugly and bad in a court of law, always to say, no, sir, I'm not going to agree. I want the prosecutor to prove that he's an expert. So the judge is you're wasting my time, Mr. Rakava. So, but with experience, my limited experience, I have figured out I should never do that. We should always allow the prosecutor to prove the expertise of this expert. A classic example happened to me in the Anuradhapura High Court, where there was a case where this child has died of liver cirrhosis. The parents of a particular belief, religion, and they are not allowing blood transfusion. So after 10 years of treatment, about 6 years of treatment, this child had died at the Anuradhapura hospital, where child was admitted in the morning. Doctors asked the parents for the consent to give blood. The parents said, no, we don't want to give blood. We know that this, if the treatment will work. If it does not work, it's okay. So the doctors tried to give blood. Parents refused it. Then in the night, the child died. Then 3 doctors had come and given evidence in the Anuradhapura High Court. the defense counsel who appeared before me had not cross-examined these three witnesses. They have come and said that it's the fault of the father, the parents. If we gave blood to this child, the child would have been saved. Then the clients came to me, and luckily the honorable judge went on transfer, and I got a rehearing where I could call another. I was given the chance to call some prosecution witnesses to cross-examine. So I called one doctor. When I went and checked these evidence, I found out that these three doctors are normal MBBS doctors who were working at the Anuradhapur hospital. These doctors were not specialized with regard to liver cirrhosis. Even the director has given evidence. And he had said that, yeah, the parents' negligence, I could have saved the child died. Then we got an opinion. That's where I think the defense counsel role is very vital. When it comes to an expert evidence who is coming to give evidence, as defense counsel, we should realize we don't know this subject. I'm not a doctor. I'm not expert on EQD evidence. I'm not expert on fingerprint evidence. We should know to extend ourselves and get an independent opinion with regard to this type of matters. And there are a lot of material, but these are things which we can explore. When we try to impeach the credit of an expert witness, I don't think that I am an expert to cross-examine this witness and attack on the doctor's credibility. Then what I did was, I went and got an opinion from Dr. Janak Silva. He was a professor in Colombo. He's a specialist with regard to liver. And Dr. Ravindra Fernando, we got an opinion. Then they told me that liver cirrhosis 10 years, it had happened 10 or 15 years back. At that time, when this thing happens, the liver, there are like holes inside the liver. How much blood you put inside the liver, it is like a water tank. The blood will just pour out. And they indicated to me that only thing at that particular time to save this child would have been a surgery of liver transplant. And Professor Ravindra Fernando indicated to me that in that era, liver transplant was not available in this country. Then I got the opinion of Professor Ravindra Fernando and Dr. Janak Silva. Then I examined the witness and I showed them that their opinion was wrong. Then the child, whatever the doctors did, they could not have saved this child. So that was, I think, that is the thing we should always keep in mind. When trying to impeach an expert, consult an expert, get an opinion, then go and attack. Then there are instances where we try to impeach the credibility of these EQDs. I'm sorry, I as a lawyer, I have read things here and there. I know that before a specimen is sent to an analysis, it should be submitted in front of a judge. Then if a person is dead and gone, if you are sending certain material to be matched, it should be proved to the under section 75, proved to the satisfaction of the judge. So I may be knowing the fundamentals, but when it comes to an expert view, we have to know to consult expert people and get an opinion, and we should be learned to cross-examine this type of witness. And this EQD's report, EQD's evidence, I think that this is an evidence where this is an area where the people from the EQD's department come and they always try to prove things against the accused. And we have very, very limited resources to attack these people because we don't know. They come out with the ways how they do it. They come out, they say that they have brought a new machine. So we are not savvy to cross-examine these people and to impeach the claim. In this thing, in an EQD evidence, the most important case for the defense would be the Obesekara Balawa case. In that case, the Attorney General's department initially called for an EQD report from the Sri Lankan EQD. Then, after they received the report, it came contrary to the view of the Honorable Attorney General's department. Thereafter, the Attorney General's department did not want to rely on this particular witness. AG's department thereafter brought in a report from an Indian EQD to establish their case. So, whenever I have a matter which touches upon the EQD in Sri Lanka, first question to the witness would be the prosecutor, the Attorney General of this country did not rely on your department. Then are you asking us to rely on your evidence? So that is my first question to these Attorney General or to these witnesses who come from the EQD's department. Thereafter, Nanta, am I okay? Or
Asela, you could take another, perhaps another minute or two, and yes, a minute or two, and I would specifically like you to address the issue of impeaching the government analyst, perhaps in heroin-related matters, because that sort of matters come up in abundance in court, and our experience is that the government analyst in that scenario is more often than not cross-examined insufficiently. So, Asil, if you could elaborate on that, and perhaps if you could conclude, then we can move on to the question and answer session.
Even in that scenario, Nanta, most of the time, it is difficult for the defense counsel to cross-examine this witness. But we are entitled to get an independent opinion from another expert witness. There are institutions where we can ask for a sample and send it for analysis. So we are only on that when it comes to heroin. Otherwise, our normal mode of cross-examination is with regard to the weight on the chain of custody. So that is the line of cross-examination. We normally go on the heroin cases. But when it comes to the exact, whether this is heroin or not, there is very limited questionnaire we can cross-examine from a particular witness from this department. But we are entitled to get an independent view. We can ask for a sample. There are institutions where we can even send it. So that is available, but we are always attacking on the chain of custody. In heroin cases, it's mostly on the chain of custody. So Nanta, on those lines, I say that this is a very vital area in evidence. You remember in the case of Satasiva, a witness, an expert witness, the entire case was dependent on an independent witness, an expert witness brought by the defense. In that case, 3 prosecution witnesses were charged for perjury. So that is how it is important. An expert evidence is important in a criminal trial. sometimes for a defendant, for an accused, it is important to discredit the witness, as well as it is important to bring in expert evidence to impeach the credibility of the witnesses who had already given. So my thing is that always we should be knowledgeable. We should know what we ask. For that, always we should go with an opinion of a third-party expert. When we try to prosecute, we need to know that when we finish the prosecution case, we have to have a person in line, standby, to come and give evidence for the accused and to discredit and impeach the witnesses led by the prosecutor. Thank you, Nathan.
Thank you very much, Asela, for that very informative segment, drawing from your vast experience as a trial lawyer. If we could move on to the question and answer session, some of the questions have already been answered by our experienced panelists, and some of the questions I managed to handle some of the other questions. There's a few more questions left. Mr. Navana, sir, if I may direct a question your way, the first question that was actually posed. The question is, kindly let me know when we are shaking one's credibility, that is shaking the credibility of a witness, injuring his character, can we show his personal things in the years back he made? Now, these personal matters would be issues such as adultery, cheating, taking bribes, issues such as that. This is the question, Mr. Navana, sir.
Just shaking the credit of a witness by injuring the character is permissible in terms of section 146 of the evidence ordinance. So there is the enabling section which empowers a counsel to discredit and shake the credit of a witness. Now, but at the same time, there are certain restrictions and limits imposed in terms of sections 151 and 152 of the evidence ordinance. Now, 151 deals with the prohibition against the scandalous questions. And if the questions are intended to annoy and insult, the court can forbid such kind of questions. Now, depending on the facts and circumstances of the case, counsel could be permitted by court to ask questions to the extent of shaking the character by injuring, shaking the credit by injuring the character, but subject to these limitations. Court can always control the extent of questioning on the basis of these limitations as enumerated in the evidence ordinance. Now, one has to be mindful of section 150 as well, because if a question is asked without a sufficient basis, then the counsel could be reported to the Supreme Court on that ground. So so one has to exercise the maximum caution in asking questions, even in a situation where he is seeking to shake the credit of a witness by injuring the character. So that would be my answer to that question, Nayantha.
Thank you very much, sir, for that elaborate answer on this point. I had a few more questions. I also had a question for Mr. Asela Serisinghe, but I see that he has already answered that question. I have one final question. Again, Mr. Navana, sir, it's actually a question that I have, not from the viewership. Sir, under section 154 of the evidence ordinance, it gives the judge a discretion in allowing one's own witness to be cross-examined. In such an instance, sir, are there any principles or rules that may be used by the, or may be relied on by the trial judge in deciding whether to allow one's own witness to be cross-examined under section 154?
Yeah. Yes. Now the section 154 is drafted very advisedly to be consonant with the other provisions of the evidence ordinance. If you look at the content of section 154, it does not use the word cross-examination, because the cross-examination is a concept that has been identified in terms of section 138, which is available only for the opposing party. What the section says instead is that it permits at the discretion of court to put questions in the manner that might have been put by the opposite party. So the language that has been used in the section has to be understood in that context. Now, the why discretion? Because it is at the discretion of court, a witness could be treated adverse, because there could be undesirable effects when one's own witness is allowed to be treated adverse. That will affect the whole system. If a witness who is going to be treated adverse by the prosecution itself, in this instance, then there could be a reluctance that is going to be infused in the minds of witnesses to come in forward. So that is an overall affectation to the system. Secondly, when you treat the witness adverse and when the questions are put in the way that the defense would have put, that would necessarily mean that you are going to confront and contradict the witness in relation to a previous statement. And that will bring in some evidence or some material which could have a prejudicial effect on an accused person. Now, in this regard, Queen versus Jassing, reported in 70 NLR, is a case where the prosecution had wanted to preempt the possibility of the witness going back and question the witness on the basis of the same manner, just as putting questions from the defense perspective. As a result, prejudicial evidence was brought in. The Court of Appeal held that reception of evidence was impermissible, even though the judge had put it before the jury. So, misreception of evidence is a ground to vitiate the conviction. So, therefore, it is of paramount importance for a court to consider the prejudicial effect that could have on an accused person in allowing a witness to be treated adverse. You know, when a witness is treated adverse, he would be asked questions in relation to a statement where he has given evidence implicating the accused. So, for example, if he had said that he saw the accused stabbing the deceased, and that question could be referred by the prosecuting counsel himself. Now, this could bring in a prejudicial element against the accused. So that is why the caution has to be exercised by the prosecuting counsel himself in the first instance, and then by court in allowing the prosecution's application to treat a witness adverse. So that is why the discussion has been vested in a court of law in entertaining an application. It is not an application which should always be allowed, but the court has to consider all the matters objectively and weigh the evidential value against the prejudicial aspect and decide the issue by court.
Thank you very much, sir.
I
for
hope
that.
I have answered the question. I don't know whether it is sufficient or
No, it did actually. It did actually. I don't know whether it was fair by the viewership that I asked one personal question of my own, but it was a very good answer that actually answered my question, sir. Thank you very much. Mr. Raghav, if I may ask one question from you, since you mentioned the Vijaypala case, 2001 SLR, Vijaypala case allowed the defense access to certain documents, of course, in a very limited context, in the context of that case. In your opinion, does the opening given in the Vijaypala case could be used, the ratio of that case be used for the defense to peruse and perhaps even obtain notes maintained by the government analyst as well? Could we go there? Could we go there? Could we develop our legal system to that level of transparency in the interest of a fair trial? What's your take on that, Mr. Raghav?
We should be entitled. Normally in EQD related matters, we use the said judgment when we ask for the notes. We should be entitled one. Otherwise, government analyst report, which they send to court, is a one-page document. They answer to the questionnaire sent by the magistrate. So using that, we cannot determine as to how they came into that conclusion. So we need to use the Vijaypala judgment and ask for their notes. Otherwise, we cannot cross-examine that witness.
Okay. So thank you very much for that answer, Mr. Raghav. I observed that we have reached almost 10 past 7 o'clock. That is 10 minutes in excess of the time allocated for the webinar. So may I take this opportunity on that note to thank all the panelists who took time off their schedules. Perhaps it was a day of rest, perhaps they had personal commitments, engagements, but nevertheless, in the interest of sharing knowledge and their experience with the rest of our brethren, all of the panelists took the time to take part in this webinar on this very important issue of impeaching the credit of a witness. Cross-examination is an art form to be perfected by any counsel who is worth their salt, and in that arsenal, the ability, the skill to discredit the opposing witnesses is a necessity. So while thanking the panelists, the learned panelists who took the time to take part in this webinar organized by the Bar Association, I must also thank Mr. Rajiv Amarasuriya, Secretary Bar Association, Mr. Pasindu Silva, the Assistant Secretary, and also Mr. Kaling Indathis, although he has not joined us today. Mr. Kaling Indathis is the President, and the Bar Association for organizing these webinar sessions. Although we started this initiative during a time of lockdown, as Tanya at the beginning mentioned, we have the Bar Association has continued this initiative, and today is the 20th installment of that great initiative of sharing knowledge with the rest of the bar. So I must be very thankful for the Bar Association for this initiative. And I'm also thankful to our viewership who took part in this webinar and posed interesting and stimulating questions. Yes, so I believe this was a successful session conducted by the Bar Association, and All the very best and good night.
Thank you. Good night.
Thank you. Thank you, Nanta. Thank you very much.